Thank you very much, everybody, for rejoining us. This next session is entitled Building Stronger Legal and Normative Frameworks for Climate Mobility. We framed it in particular around two advisory opinions that have come forth in the recent month from the International Court of Justice and the Inter-American Court on Human Rights. Both of them looked more broadly at state obligations in the context of the climate crisis. And also both of them had some opinion, some things to say about climate mobility and the protection obligations, the state obligations that arise in that context. We also, in the context of tomorrow's discussion on the existential threats of sea level rise, see important legal concepts playing or at stake around continuity of statehood, maritime zones. So there's a bunch of a range of legal questions that are at stake, that are in play when we discuss climate mobility. And so this panel will be looking at those legal issues at stake, the normative developments that are underway, and how we can further advance progress in creating a normative framework to address climate mobility. I'm very pleased to introduce our two keynote speakers for today's session. We'll be guided by His Excellency Ralph Regenvanu, who joins us from Vanuatu, the country that started the request for the advisory opinion by the ICJ. We're very pleased that you're joining us today. Minister for Climate Change Adaptation, Energy, Environment, Meteorology, Geohazards, and Disaster Management. Sorry, I had to read this. Thank you for coming, and the floor is yours.
Thank you, and good afternoon to you all, Excellencies, colleagues, friends. I'm happy to, it's a pleasure for me to be able to make this important, join this important discussion on climate justice, human rights, and mobility, and I thank GCCM for convening it at such a crucial moment in Climate Week at the General Assembly. So for Vanuatu, the ICJ advisory opinion wasn't just a legal milestone. It's also a political and moral turning point. It confirms what small island developing states have been saying for decades, that states have binding obligations under international law to prevent climate harm and to protect human rights. The ICJ's findings complement the opinions of the International Tribunal of the Law of the Sea, rendered in 2024, and the Inter-American Court of Human Rights in July this year, which together send a powerful and unified message. Climate change is not only an environmental crisis, it is a human rights crisis, and I quote the decision, a quintessentially universal risk that threatens lives, uproots communities, and unsettles the very foundations of statehood and the international order. Our task now is implementation. Legal clarity has been achieved. The question is whether governments will act with the urgency and responsibility that the law demands. At the multilateral level, Vanuatu is taking steps to bring the advisory opinion to life through the United Nations General Assembly. Together with climate-aligned partners, we are discussing ways to firstly endorse the ICJ's findings as substantive and authoritative guidance on international obligations, and to address structural inequalities in the international climate regime that have slowed ambition. For example, by establishing reporting mandates, open-ended working groups, damage registries, or requests to expert bodies like the IPCC and the International Law Commission. This is not about duplicating the Paris Agreement. It is about complementing and strengthening it, clarifying the legal baseline for ambition and responsibility in a forum that is not constrained by consensus politics or the veto power of a small minority. At the national level, Vanuatu is determined to model what implementation looks like. Our new NDC 3.0 integrates the court's determinations across multiple forums. We have revised due diligence and environmental impact assessments to be screened through an ICJ implementation test in our licensing and procurement systems. We are going to put in place procedures to invoke state responsibility and remedies including escalation pathways. Domestic legislation to enshrine the principle of non-refoulement, ensuring no one is returned to territories where they face climate-induced harm. Depositing the geographical coordinates of our baselines and maritime zones to secure our statehood despite sea level rise. Establishing a national loss and damage claims and evidence facility to enable reparation claims grounded in science-based attribution. And submitting a UNFCCC alignment communication within 12 months of our NDC's adoption. Each of these steps is concrete, practical, and legally anchored. Together they show how a small island state can lead by example in giving effect to international law. The ICJ advisory opinion gave us clarity. The forthcoming United Nations General Assembly resolution will provide political mandate. Our NDCs demonstrate pathways for implementation. What we need now is collective action. Governments everywhere must align their policies with the obligations that the law and justice demand. The right to a healthy environment is fundamental, protecting the dignity of people forced to move, while also safeguarding the right to remain on their ancestral lands, is a matter of peace, justice, and survival. For Vanuatu, for our Pacific family, and for all vulnerable communities worldwide, the stakes could not be higher. Let us meet this moment with solidarity and with responsibility. Thank you.
Thank you so much, Minister, for laying out the historic stakes, really, of this ICJ decision. I would like to call on our next speaker, Ms. Victoria Hallam, Deputy Secretary for Multilateral and Legal Affairs in the Ministry of Foreign Affairs and Trade of New Zealand. Thank you, Ms. Hallam, for joining us, and the floor is yours.
Good afternoon. I'd like to thank the organisers of this summit, and I'm very pleased to be here. And I'd also like to acknowledge the role of Vanuatu in taking up the cause of the Pacific Island law students and turning the initiative to seek an advisory opinion from the ICJ into a reality, as well as to acknowledge all those that worked to achieve that result, including the Global Centre for Climate Mobility. The outcomes to take a unanimous request by the General Assembly to the ICJ, which then in turn led to a unanimous opinion from the ICJ, are truly remarkable. So my comments today will focus on one aspect of the advisory opinion, sea level rise, and the fast evolving area of international law relating to preservation of maritime zones and preservation of statehood, and how that relates to the protection of people. Sea level rise is an important issue for many coastal states, especially low-lying ones, but for small island developing states, the issue is of paramount importance. Leaders from the 18 members of the Pacific Islands Forum, including my own country, have recognised that the threats of climate change and sea level rise are the defining issue that imperils the livelihoods and well-being of our peoples and undermines the realisation of a peaceful, secure and sustainable future for our region. Now, sea level rise is a multifaceted problem, but Pacific Island Forum leaders have paid particular attention to the legal aspects. This is to ensure the protection of statehood, which underpins their agency to protect their peoples, and the protection of maritime zones, which contain essential resources and are a key part of what it means to be a small island state. Our leaders' concern was necessary in a context where concepts of disappearing states and ambulatory baselines were gaining traction, especially in the international legal community. While the advisory opinion devotes only 10 paragraphs to this issue, they are highly significant. The court has done 3 important things, all for the first time. Firstly, it confirms that there's no obligation on parties to UNCLOS to update their charts or lists of geographical coordinates that show the baselines and outer limits of their maritime zones once these have been duly established in accordance with the Convention. This means that maritime zones will not shrink, despite coastlines receding due to sea level rise. Second, it confirms that the disappearance of a constituent element of an existing state, in this case, complete loss of a state's territory, would not necessarily entail the loss of its statehood, thus endorsing a strong presumption of continuity of statehood in these circumstances. And thirdly, it establishes that there is a customary law obligation on states to cooperate in addressing sea level rise, including in its economic, social, cultural, and humanitarian aspects, consistent with the UN Charter. This requires states to work together with a view to achieving equitable solutions, taking account of the rights of affected states and their populations. Judge Orescu's separate opinion elaborates on the legal rationale underpinning these conclusions and notes that they were already thoroughly elaborated in the International Law Commission's work, which concluded in 2025. Judge Orescu also goes somewhat further in specifying that the court's findings on maritime zones is not only a correct interpretation of UNCLOS, but also a norm of customary international law, supported by state practice and opinio juris. He also sets out his view that the recognition of the court of the strong presumption of continuity of statehood should have gone further by saying that the loss of territory does not entail loss of statehood, and that the concurrent loss of a permanent population also does not lead to loss of statehood, thus reinforcing the findings of the ILC, which were more of the nature of there being a principle of continuity of statehood rather than simply a presumption. Judge Orescu also specified that the equitable solutions, which the court said that states are obliged to work together to achieve, have as their sole purpose to bring equity for the states and populations affected by the negative effects of sea level rise to protect their existing rights. So we can see that legal and normative frameworks with respect to the preservation of maritime zones and statehood have indeed been substantially strengthened through the advisory opinion and the conclusions of the International Law Commission in their groundbreaking work. In a short time, the law in this area has shifted from a state of obscurity and doubt, and indeed anxiety, to a state of clarity and certainty, opening the way for constructive discussions on consequential issues. This is important for the protection of people and enabling positive adaptation journeys for communities. Ensuring that states continue to have a voice and agency on the international stage means they can act to protect their peoples, their continued identity as oceanic nations, and their access to the resources of their maritime zones. This legal certainty opens the way for practical cooperation. One example of this is the Whalepili Union Treaty between Tuvalu and Australia, which takes as its starting point the continuity of Tuvalu's statehood and sovereignty, notwithstanding sea level rise. This legal certainty also sets the stage for the ongoing work of the UN General Assembly on sea level rise, which is one of the key forums in which states have an opportunity and indeed an obligation to progress their duty to cooperate, as articulated by the International Court of Justice. Now, this rapid development of international law did not come about by accident. It was the result of advocacy by small states, working in concert with the legal institutions of the United Nations. In particular, the Pacific Island Forum leaders' sea level rise declarations on maritime zones in 2021 and on statehood and protection of persons in 2023 were the stones dropped in the water from which many ripples emanated. The two declarations carefully and thoroughly set out a compelling and legally sound articulation to support continuity of maritime zones and statehood and the duty to cooperate. Pacific Island Forum members then deliberately promoted these positions through other international groupings and bilateral discussions. And what followed were concurring statements from states in the UN and joint declarations by the Organization of African, Caribbean and Pacific States, the Alliance of Small Island States, the Climate Vulnerable Forum, the Korea Pacific Leaders Declaration, and the Commonwealth Heads of Government meeting in the Apia Oceans Declaration, just to give some examples. These statements and declarations, along with the absence of any objections, gave the ILC and the ICJ the material on which to draw their conclusions. So it's a great example of how regional groups can constructively drive multilateral solutions to global problems. It also demonstrates that new treaties are not the only way to develop international law, which may be important given how difficult it is to negotiate treaties in the current context. Thank you very much for your attention.
Thank you so much, Ms. Hallam, and I think you spoke and underlined very well the important reinforcements of the rights of states in the context of the climate crisis. The previous session, we talked a lot about communities and people, and I think the certainty that states are demanding is obviously an instrument to give certainty to people also in the context of the climate crisis. And the panel, I think, will touch on some of the human rights elements of these advisory opinions as well. I'm very pleased to have His Excellency David Donoghue with us to moderate the panel discussion. Ambassador Donoghue is familiar maybe to many of you as the co-facilitator of the SDGs, the Agenda 2030 resolution in the UN General Assembly, and also the New York Declaration for Refugees and Migrants. So he's an ally to many of us who come to this conversation from the migration and refugee side. And I'm very pleased that he's with us today. David, the floor is yours.
Good morning, everyone. I'd like to call on the panelists to join me here on the stage. I think we have 5. Please, anyway. Great. Well, I'm going to introduce the panel. Oh, there we are. Fine. Okay, great. So beginning at the end, we have Gerhard Schlautrauf, who's the director of the Climate Diplomacy Department in the German Federal Foreign Ministry. Beside him, we have, that must be, is it Liliana? Yeah. Liliana Gamboa, who is non-resident scholar at the Carnegie Endowment for International Peace. And we then have your Jocelyn, I presume Jocelyn Perry, Senior Advocacy and Program Manager for the Climate Displacement Program at Refugees International. And we have Elizabeth Campbell, who is the Director of ODI Global and also a former Deputy Assistant Secretary in the Bureau of Population, Refugees and Migrants at the US State Department. And then beside me here we have Leah Zamor, who is a Senior Research Fellow at the Zalberg Institute for Migration Mobility at the New School. You're all very, very welcome. We have 3 basic questions just to look at, building on the very interesting opening presentations from our keynote speakers. So the first question really would be, what key rights are at stake when people and potentially whole nations face displacement because of the impacts of climate change? So what are the rights that we have to address? Secondly, how do the advisory opinions to which the keynote speakers referred, how do they frame the obligations of states in the context of the climate crisis and especially the displacement aspect? And thirdly, where do opportunities arise for advancing a rights-based approach to climate displacement? What promising models might there be? So these are the 3 starting points for our discussion. And I'd like to begin perhaps with Gerhard, if you, at the end of the panel, if you would like to offer some thoughts on those issues. You may need to share.
Yes, thank you, David.
Okay.
Thank you for having me today. I must say I feel particularly unqualified to be the first person to speak because I'm a diplomat. I'm not a lawyer. I'm not a legal expert. As a diplomat, we are looking at the third question you have been asking: the opportunities that come now from the advisory opinions to bring that back in a political process, as Ralph was mentioning. How can we work on this in the General Assembly? And I don't have a good answer to that yet, so I'm also listening. But perhaps my perspective is, if we get a General Assembly resolution, how do we make sure that it is meaningful, that it doesn't create divisions or entrench old divisions, but leads us forward? How will we make sure, as Germany, as Europeans, that we can support it? Will it be something short? Will it be something long? And how can we register or endorse the findings of the advisory opinion that I think we all understand is a landmark opinion in a way that we can build on then in the years to come? Thank you.
Thanks, Gerhard. Elizabeth, would you like to follow up?
So, hello? So I think on the question of rights, I mean, there's a number of things at play, I think, that we need to think about. The first thing is just to remember, even though we have this new advisory opinion, we all know that it's going to take quite a lot to implement it. And at the moment, when we think about the frame that determines the rights that vulnerable people have, or if we kind of think about it as the protection frame, or it very much stems from the 1951 Refugee Convention. And I think, as all of you are fully aware, it has very specific criteria for what constitutes a refugee. I think we had a 25-year debate about whether there's such a thing as a climate refugee and all of these things. But the point I'm trying to drive at here, that document helpfully lays out a number of rights to which refugees should be entitled once they cross a border for reasons not of their own making, fleeing persecution. Those rights include things like access to documentation, the right to work, the right to access social services in the country to which they fled, these kinds of things. So at a very basic level, these are the simple things that we need to be thinking about. More broadly, what we need to be thinking about, and this ironically is the best moment historically for us to be doing this. We're in a moment where we actually have an opportunity, I would argue, politically to do this, and it's something very much that the GA should consider taking up. Not how to retrofit the 51 Convention to more effectively address this group of people and the context which we're discussing today, but really, what is the new normative framework that more effectively addresses people who are so impacted by climate change? And here I would argue we should not start from what we have, but really think bigger and bolder. For a very long time, the sort of conventional wisdom has been, don't touch anything, don't touch the architecture, don't touch the plumbing, as we say, because whatever you do, if you open it up, it's only gonna get worse. Well, guess what? It's been touched, and now we have an opportunity to shape it in a way that actually creates more, stronger protection opportunities for people, including those impacted by climate.
Thanks, Elizabeth. Jocelyn, would you like to continue?
Sure, thank you so much. And I think I've been asked to address sort of what the AOs say on the application of non-refoulement specifically, and that I mean building on the current architecture that already exists, so not even building a new architecture or developing anything new for people affected by climate change. The ICJ recognizes that states already have obligations under the principle of non-refoulement, where there are substantial grounds for believing that there is a real risk of irreparable harm to the right to life. And I'm quoting here from the AO, in breach of Article 6 of the ICCPR, if individuals are returned to their country of origin. And this is, going back to precedents set by the Human Rights Commission, the case Te Toyota versus New Zealand that many are familiar with for many years, that people displaced across borders may qualify as refugees under the existing refugee convention, or might be eligible for complementary protection under various human rights conventions as well. And then bringing in the Inter-American Court, because of course, countries aren't just obligated under the UN Refugee Convention if they're signatories, but also their regional and domestic architectures. The Inter-American Court of Human Rights advisory opinion recognized that people displaced across borders in the context of climate change may be entitled to international protection. And importantly, that displacement is a response to both structural and compounding risks. And so it's not just a singular climate event that is displacing an individual, but that there are these intersectional and compounding structural causes and risks that put people at differential risks to harms from climate change and affect their ability to adapt to climate change and to be resilient in the face of climate change. And so I won't get into too much domestic law here in the US, but of course, in response to the US's attacks and threats to withdraw from the Refugee Convention, I think it's important to note that the US has already domesticated the Refugee Convention into our domestic laws, and that we have obligations under the domestic law for the protection of asylum seekers and refugees here in our country. And so the withdrawal is a mere political stunt intended to reopen a conversation around protection of migrants and asylum seekers and refugees. But of course, we've already been derogating from our obligations under international law and under domestic law, that we have not been treating asylum seekers and refugees with the rights that are already enshrined in the US Constitution and in US law, and that we need to have both political, normative, as well as legal challenges to this derogation here in the US and in many other countries, because under the Refugee Convention, many refugee host countries are not meeting these obligations that you've just mentioned. Rights to documentation, rights to employment, rights to freedom of movement. And we have many, many existing refugees who are unable to adapt to climate change because of these issues, because they're unable to move out of an encampment environment in a place that's exceptionally climate vulnerable. So we need to create the support structures for these individuals. And then if they're crossing a border because of compounding effects from climate change, ensure that this principle of non-refoulement is respected. Thank you.
Thank you very much, Jocelyn. Liliana, would you like to come in on this?
Sure, thank you. So looking at this bright spots, or where are the opportunities, I think when it comes to crafting legal and policy responses for climate mobility, there's not going to be a sort of one-size-fits-all approach, because instead we're going to need a range of tools that ensure that the responses are context-specific, they are attuned to the particular needs of those affected, and those include those who are at risk of displacement, those who choose to move, those who stay behind, as well as the host, transit, and diaspora communities. So governments are beginning to prepare in various ways, and I like to highlight, for example, that what we are discussing today bring us the attention of, these are two states, Chile and Colombia, who asked the Inter-American Court for guidance on the obligations and principles that should inform the individual and coordinated state measures to deal with involuntary human mobility exacerbated by the climate emergency. That's what they asked the court. So why this is important? Because it demonstrates the state's commitment to international cooperation. It's a vote of confidence in the court. It shows relevance to address this global challenge, and also the best tradition from the region on development of international norms, right? So for 50 years, the states in the region have been resorting to the Inter-American Court to ask for guidance when they have doubts about what their obligations are in the protection of human rights. Though these advisory opinions are not binding in nature, but they do have legal authority and weight in prescribing what states ought to do under the Inter-American Convention. So they've been an actual source of law development for our courts in the region. Many constitutional courts, Supreme Courts have based their decisions at the national level on them. So I want to also point that, for example, given that climate change, in the context of climate change, research shown that most people will move within countries. This highlights the role of the domestic courts, as Jocelyn was saying. But I'm going to actually use an example from the Constitutional Court of Colombia, drawing back to my point that actually it is these courts that usually base themselves on the inter-American jurisprudence, which actually last year stated that the impacts of climate change, both in terms of sudden onset hazard and slower onset processes, can be legally considered causes of forced displacement and therefore place an obligation on the state. So when it did that, it actually prescribed several provisions to restore to those who were affected by climate impacts, including the humanitarian necessary assistance to guarantee the right of food, potable water, housing, clothing, health, sanitary services, etc. Also, the risk of vulnerability assessment of the land where they have been displaced and different options to protect whether they could go back or not. But then most importantly, I think they also, the court does a relevant contribution to policymaking because it invites the monitoring of the progressive restitution of the people's rights by the ombudsman. It urges the Colombian Congress and the national government to develop the policy framework to address environmental and climate change displacement and ensuring the guarantees and human rights of the people displaced due to climate and environmental reasons. And I perhaps just finalize with another interesting model that already has been mentioned this morning in the key remarks by the Deputy Secretary, which is the Australia and Tuvalu-Falepili Union Treaty, considered the world's first bilateral agreement on climate mobility. This treaty represents a collective security and foreign partnership, which establishes a first-of-a-kind mobility pathway for Tuvalubans to obtain permanent residency and ultimate citizenship in Australia. It is unique because it specifically references climate change as the key force shaping movement between states. But I want to highlight 3 points of why this agreement is so worth mentioning. One is because it includes the mobility with dignity concept in the treaty. And by this, they mean that it's not just about accessing entry and stay in the country, legal stay in the country, but also it must provide access to Australian education, health, key support, family support on arrival, etc. So there's several characteristics that they include to ensure that people can actually move in dignity when they arrive in Australia. Also, because it doesn't have an age limit, and this speaks a little bit of what we were talking about before, some of the people who are left behind. So with some of the labor mobility, they have age limit. This does not. Anyone can apply, children as dependents, and then there is no limit, upper limit. And then finally, because it also focuses on honoring the right to stay. So it actually supports resilience by strengthening the support in Tuvalu, providing climate funding for climate adaptation, for Tuvalu coastline to expand safe line, as well as recognizing, as it was mentioned, the commitment to recognize statehood and sovereignty of Tuvalu. So I think I'll leave it here.
Thank you, Liliana. And Leah, finally.
It just comes, oh my God. Okay. Hi, everybody. It's an absolute honor and pleasure to be here. I have the luxury of coming last, and so mainly I endorse what everybody has just said. I want to, and my brief has been actually to speak about the right to stay, and I'm going to come back to that in a moment. But first I want to endorse what Elizabeth said about now is the time to go big. We need a new system. The 1951 Refugee Convention has done incredible things. It's been a sort of a pillar of the sort of multilateral order for a long time. It has internal problems. It puts the onus on the host states. It doesn't give a right to not to be forcibly displaced. There's a lack of accountability mechanisms. You've got a right to non-refoulement, but not a right to actually access a territory. And so we're seeing those kinds of internal problems now being compounded by sort of geopolitical and external political problems. So I don't think we have much to lose by going big. And I would like to propose, if we were going to sort of reimagine a global protection system that was absolutely inclusive of people who are displaced by climate change or who are impacted by climate change, but actually wish and have a way or could have a way of supported to stay in their homes and homelands, it might look something like this. Protection for all displaced people. This would include IDPs as well as people who cross borders. It would include climate displaced people, just as it would include people fleeing persecution. And it would incorporate a right to move and a right to flee, which is crucial because the next component would be a right not to be displaced in the first place. Now, if you have a right to stay but you don't have a right to move, you have a cover for containment. And this, of course, is a huge feature of the problems of today's landscape, where there's a kind of containment regime where people are I think some of the speakers at the very end of the last session, which I had the privilege to hear, were talking about enforced immobility or sort of involuntary immobility. And that is not what we want out of a right to stay or out of a right not to be displaced. But to the extent possible, people should not be forced to leave their homes and homelands if there's any way that they, in the obligations that both of these advisory opinions talk about, have the capacity to stay if they were supported to do so, and they ought to be supported to do so. The third element would be accountability for the drivers of displacement. And here I want to put a particular emphasis on what I call exogenous drivers that are outside the home country or even the region of origin. Now, climate change is probably the most obvious example of an exogenous driver, because the major emitters, sort of the northern states and their heavy industries, are the main causes. I think it's 92% of historical emissions come from global north states. And of course, the main impacts of this are not in the global north, but are in fact in the places that are most prone to displacement in the global south. Same thing with sort of economic drivers of displacement, as well as geopolitical violence. And here is another sort of internal gap or omission within the 1951 system, which is that it excluded foreign occupation, geopolitical violence, et cetera, as a grounds for protection. And the fourth one would be a leadership shift. And we're already seeing this. We heard from the Minister of Vanuatu. South Africa and the Gambia were the ones that brought the ICJ suits under erga omnes norms about speaking of geopolitical violence. So that might be a very, very different system. Now, speaking specifically about the right not to be displaced, I think both advisory opinions are quite good. You have to squint, especially in the ICJ opinion, but it's there. So if you control F just for the word stay in the Inter-American opinion, you find one hit. It's in footnote 737 for those who I control F. This is what I do. It's in footnote 737. It's regarding the right of children to be involved in mobility decisions. But that's it. So there's no explicit right to stay. There is, though, and I would put it to this group whether this language is actually more helpful. There is an explicit reference to the right not to be forcibly displaced. And this builds on a number, especially in the Inter-American system, but also in the African regional human rights system. And it's less of a standalone right, but the European Court of Human Rights is also, I think, there on the right not to be forcibly displaced in a kind of derivative way. And so the regional courts are already there. And I think the advisory opinions sort of build on that. So it's in paragraph 414 of the Inter-American decision, where the explicit reference is to the right not to be forcibly displaced. Actually, then there's a footnote. I'm a reformed lawyer, so I really like footnotes. It only cites to 2 of the cases, but it could have cited to 22 cases just within its own jurisdiction that literally have that phrase, the right not to be forcibly displaced. We're also seeing a number of national legislation, Colombia being a prime example, where they had their IDP protection law. I think it's Article 2 says Colombians have a right not to be forcibly displaced. So there's a kind of a groundswell at some level of a recognition of this right. And so I think that's something that the advisory opinions are building on. And then the flip side of that right, of course, is the obligation to prevent. And both decisions are very good here. The ICJ opinion is very much about the obligation to prevent environmental harm, which is a prerequisite to preventing displacement. And so you can sort of read a right not to be displaced out of the preventative norms. And I would say the same thing with the Inter-American decision. So I'll stop there for now.
Okay, Leah, thank you very much indeed. Thanks to all panelists for what has been a very thought-provoking discussion. For me, perhaps the most salient idea is the one about whether the advisory opinions create a new context in which we should be looking at a radically new framework. Obviously, we have to examine the implications of the opinions, and some of the panelists have already done that. But I'm sympathetic personally to the idea that we have a new situation. I mean, I remember negotiations around the New York Declaration and the two global compacts on migration and refugees, respectively, involved a lot of soul searching about whether there should be a distinct category created. At the time, a more cautious view prevailed, but arguably, I'm personally open to it. Arguably, we now have both an opportunity and a justification to look at creating a new framework. There were many other points which arose in this discussion, but I'd like to open the floor now to the audience and just ask whether you would like to frame comments or questions either to the whole panel or to individual members. And so I see, let me begin here, please. And if you like, you might indicate who you are, where you're coming from. Thanks.
Hi, I'm Anna. I work for the Sabin Centre at Columbia University, and I'm also a human rights student at Columbia University. I had a question on the ICJ and what it says about non-refoulement. Specifically, it draws the norm from the Teitiota decision, but the Teitiota decision also found that he could be returned to Kiribati because there was still enough time for intervention, and because of this time for intervention, there wasn't a real and imminent threat as required by Article 6 of the ICCPR. I was wondering, kind of, because this has now been crystallized in the ICJ advisory opinion, what sort of pushbacks can we expect from asylum regimes and mobility regimes, global north states, other states, against non-refoulement, kind of stretching out this kind of interception time, and kind of what civil society and lawyers could do to make sure that that protection is upheld? Thank you.
Okay. Thank you, Anna. Maybe who would like to respond to that? Leah, yeah.
I'm happy. So I agree with you. I mean, Teitiota was, in some sense, a kind of a landmark case, but it didn't go far enough. It certainly didn't go far enough. So we need more strategic litigation around non-refoulement, absolutely. But I also think that if we're thinking about this politically, we have a sequencing issue. And I think that's where prevention comes in. If we could start to get prevention right, I think we would open up the space for states to actually start respecting non-refoulement in a proper way. Now, there's been a lot of talk in recent years about addressing root causes and these things. I think it's mostly been a cover for containment. But if that were to change, if we were to come up with ways, and again, getting back to the exogenous drivers that I mentioned, if there was a way for third states, and particularly sort of the more powerful states, to actually start to recognize their role in driving displacement, because they're the ones most concerned about people coming. So in theory, they have a vested political interest in actually, hopefully, doing the right thing on prevention. And so if we could start to get prevention right and imagine non-refoulement and prevention as sort of sides of maybe not the same coin, but in the same coin collection, then I think we might start to see it. But the main one is that non-refoulement is an international norm. It's arguably a customary international norm. It absolutely has to be protected. And so those of us that are in a sort of capacity to litigate around this issue should go full steam ahead. We should not take Teitiota to be kind of the be-all and end-all. It was a good start, but not nearly far enough. And I think both of the advisory opinions do well on this, although I think someone mentioned the sort of supplemental opinion. I forget the judge's name, but he was also kind of critical of the ICJ's opinion and saying they didn't go far enough on non-refoulement, and I think that's right as well.
Thank you, Leah. I saw a question at the back.
Yeah, I am Michael Galopter. I run the Yale Center for Environmental Justice, and we have a project called Framing Climate Migration. Go big. Right, it doesn't feel like the moment to go big to me. Meaning, we're actually working off the idea that most people don't know what climate mobility is yet. Most electeds, most publics, and that we need to take some time as a community. of folks working in this space to figure out how to lay different umbrella under which this issue can emerge, because the current environment is very difficult. So I'm just interested in, besides legally, which I hear great stuff about, right? What would it mean to go big? Is it the right time, or should we go big as a community in thinking about strategy for when we can maybe move it in a different political environment? And who should go big? Who is the who there? Yeah.
Thanks, Mike. I'll take another couple of questions and then we'll put them to the panel. I saw another hand here. Please, yes.
It's not so much. Hello, everyone. My name is Chiamaka. I'm a Climate Mobility Fellow with the GCCM. I wanted to add to the comment you made about going big. And, I feel like it's good to sound aspirational, but I think in this current political climate, it makes it harder to reach a consensus, to advance, binding legal frameworks for the recognition of climate refugees, for example. And so I'm also thinking about this going big. What exactly does it mean? Are we not alienating the same parties, that we want to bring together to reach a consensus? How can we be feasible when we advance, aspirational ideas like this? Thank you.
Thank you very much. Anyone else? Yes, please.
Hi, thank you. Steve Myron from Researching Internal Displacement Publishing Platform and the Refugee Law Initiative. So one thing you haven't talked about is the right to reparation, which was upheld, as was the primacy of human rights law. And under human rights law, as articulated in the guiding principles on internal displacement, displaced people have the right to a solution. And most, I would argue, of the people who are displaced in the context of climate change are not newly displaced people. They are people living in protracted displacement, and those numbers are growing. And they're not on government radar screens, and they're often not on the radar screens of development organizations. So is there a way to use this inflection point to really look back and to start delivering justice to the forgotten people who aren't in IDMC statistics because they don't get the data that shows the people who have unresolved displacements? Is this not an opportunity? And I think of the minister from Vanuatu talking about that loss and damage registry. Is there also not a need now to sort of quantify that loss and damage so that as we make progress, it can be addressed?
Thanks, Steve. Elizabeth, I might ask you just to come back on the think big question.
So, I mean, we're living through a moment where the post-war international architecture is disintegrating in front of our eyes. It's being torn down. Key power players are pulling their money and their support out. That's going to continue, and it's not going to come back. It's not like this is just a break in the system, and in 4 or 10 years, it comes back. And many of the actors who are doing that are coming forward with a very clear agenda. We don't want any of these things anymore, and all of these problems that exist, this is the approach that we're taking to managing these problems. So one of two things is going to happen. Many of us who I suspect are in this room, or many of us on the panel, who believe that whether climate mobility is an issue that needs to proactively be addressed through international solidarity and cooperation, and that people have rights, and even people who are unjustly facing these situations should be protected. That approach, we either have to scream from the top of our rooftops and sort of start to say what it is needs to look like, and to build a political movement around it at every single level, to include, I would argue, the global level, and proactively say, no, in fact, we had a protection regime. It came out of a particular historical moment. It served a purpose. It did protect some people. It's wholly and completely inadequate for this moment. And what we need now is a different protection regime, and it's going to look at these kinds of issues in context and be more inclusive. That's not the same thing as saying, today there's 140 million displaced people, so we want to, include that number should be, 10 times bigger, because this is what people fear, right? That you just sort of make the pie bigger. No, we want to be smarter. We need to proactively say the current architecture is actually not effective for providing protection in this current historical moment. So if we don't put that on the table, then the direction we're going to be moving is the direction that we're seeing at the moment, which doesn't really provide us the types of resources, tools, frameworks, normative, legal, otherwise, to begin to more comprehensively find solutions at the local level.
Thanks, Elizabeth. On Steve's point specifically about IDPs, would anyone like to come back? Jocelyn?
Yeah, thank you so much, Steve, for the question. I mean, it's part of a broader conversation that I think it's really important to bring in here, which is participation of people that are affected by climate change in all of these pieces, and mostly people who have been historically disenfranchised in all of these spaces. And so I think it's really critical, the points that have been raised over and over again about the advisory opinion, that states will have the right to sovereignty and continued statehood even in the wake of climate change, which of course will affect small island developing states the most. But when we look at the population of small island developing states, I think it's about 65 million. When we look at the number of already displaced people in the world, we're talking over 120 million people. And those people effectively have zero representation in multilateral fora, here at UNGA, at UN climate change negotiations, at the national level. Stateless people, refugees, even often internally displaced people are disenfranchised, marginalized, or flat out ignored in every national adaptation plan, nationally determined contribution, and in local policy making. Because of course, there's the thought that refugees will return home, that IDPs will return home, but they're in these protracted situations for 20, 30, 40 years. Many people are born in the displaced context and remain there because of the lack of rights, the documentation, employment, encampment issues. And so bringing a path to participation, I can't sit here as a non-displaced person and say what every solution in every context is going to be. Building a pathway to participation for those groups at every level of governance, I think, is really critical, so that they're not just, tokenistic participation pathways, but have a seat at the actual negotiating table. And that brings in, I think, the right to reparation, which is the money to do this. So I think the organizers planned well that this is coming on the heels of the finance panel, because having the legal right to anything is useless if you don't actually have money behind it. So Leah's point around the exogenous factors that are leading to displacement brings in this idea of not just capacity to respond, but also culpability. So this is true in the refugee regime globally, but nowhere more so than climate change, that the global north has caused these crises that are causing people to be displaced and owes money to the communities so that they can build the right to stay if they can, and owes access to migration pathways that are safe if people are forced to and choose to move in the context of climate change. And so I'll just end saying about we talk about climate change, we're all under the same storm, et cetera, but we're not really all in the same boat here. Some people are in houses that are built to withstand Cat 5 hurricanes in Florida. Other people are in the ocean, not even in a boat, without being taught to swim. So how do we build the capacity of people to adapt and to fund that, as well as build our political and legal systems to do so?
Thanks, Jocelyn. I saw a few other hands a moment ago. Yes, please, come out.
Thank you. I just wanted to add 2 points with regard to those who expressed doubt about suitability and time. All the achievements that we have that were stated and outlined earlier, both by Minister Ralph and Victoria. When we started this work literally 5 to 8 years ago, these were ambitions. Now they are realities. People laughed and people joked that this was not possible. But today they stand as a tenet of how we can move forward. And I think it's, as it was told 85 years ago by Churchill, the only failure is to give up. Never give in, never give in, never give in.
Thanks, Kamal. Any other comments, queries, challenges? I'd like to come back a bit just to the question of a resolution in the short term that Gerhard was referring to. I mean, what kind of advocacy will be needed in relation to that in the resolution? I mean, in a sense, we've been talking about something which is possibly more medium term than then I mean, in the short term, there will have to be something to build on the actual advisory opinions. Gerhard, do you want to take up that point again?
Thank you. And the question was how developed countries will relate to the decision also, and what pushback there might be. So I just want to clarify that Germany has throughout supported this process. We have been member of the core group that brought the process to the ICG in the first place, started by Vanuatu, but then building unanimity actually in the General Assembly to bring this to the court. So and we have welcomed the advisory opinion, and there are several aspects that I think are very important in the opinion that were also part of our submission to the court. And one of them is the applicability of international law as a whole to the issue of climate change. And I think many of the questions that we are discussing here today, for that is very relevant, that we are not just looking at the treaties, but that the entirety of international law also informs policies on this. I have to make a point that was made here twice about the responsibility of the global north for the climate crisis. And Leah, I have to challenge you on the 90%. I don't want to get into this debate, but I will tell you in a moment why I come back to that. Historical emissions are part of the problem. Global north country defined as those, I come from climate finance, as those who feel obliged to do climate finance, are somewhere between 25 and 35% of historical emissions. I don't want to make this point to say that we don't recognize our responsibility, but if your diagnosis isn't right, your therapy is not going to be right. And I think there's a really important point in the advisory opinion to underline the necessity of international cooperation, and that all states have to act in their highest ambition to mitigate climate change. And this is important because there are emerging states that do not act accordingly in relation to their own share of global emissions. So that's a point I want to make. Now coming back to your question, David, I think we have an opportunity to bring these issues now to all international fora. And my hope would be that a new GA resolution provides a basis for this to discuss climate change, not just in the framework of the treaties or the UNFCCC, but basically mainstream it to all international fora. Thank you.
Thanks, Gerhard. Liliana, can I come back to you on the implications of the Inter-American Court of Human Rights advisory opinion? How can that be best translated in the form of a resolution, do you think? What's the diplomacy around that?
So actually, the Inter-American system has been building consistently, and in the last couple of years, jurisprudence on this regard. So it's not just the advisory opinion, but for example, the Inter-American Court in a previous advisory opinion and on a case against Peru, it already recognized the right to a healthy environment, actually as a fundamental right to even have human rights. So it considers like something that is paramount. The Inter-American Commission issued a resolution last year on climate mobility, on the nexus of climate, the climate emergency and human rights. So I think the region is on the right path. Last year also in the 40th anniversary of the Cartagena Declaration, which is one of the few frameworks that actually extend the scope of the refugee definition, it dedicates an entire chapter on the regional work that states needs to do in order to provide the necessary response for climate displacement. So I think that actually there are several initiatives that are putting this in motion and in wheels. So now what I think the key aspect of the Inter-American Court that we'll use is sort of framing into the human rights. And for that, I think the national courts, the national institutions are going to be key in upholding whatever it is that they build under those guidelines and principles. And I do think that the Inter-American Court calls on a various ability to say, it says humanitarian visas, legal pathways. So it calls on to everything that exists in the region to provide solutions, including also cooperation, which is so much needed. So I think that it's going to take a while. We're going to see it slowly, clearly. But I think that it is an opportunity this moment. So think big or not, I think it's debatable in the sense that we just have to think differently. Think big, sometimes I think we always think about global, and it seems to me that actually the most interesting solutions are coming out either at the very local level, at a community level, country level, regional. So regional solutions like free movement regimes that are including climate, that are including portability of rights, for example. We're looking now at Carnegie at a piece on understanding the Organization of Eastern Caribbean States free movement regime, and they have a contingent right policy that allows people to have sort of portability of social rights regardless of the movement as an interesting way. So I think that big or not, it's about how do we do things differently. And to the point of IDPs, I think that also there is a moment now, an opportunity also to think and create policy solutions that no longer categorize people and put them into different sort of on the move or IDPs or whatever, but actually identify and support them in their climate vulnerability, right? And so provide solutions so that we can honor the things that we have said this morning about the right to stay, the right to move if you are at risk, having the reparations that are needed for those who are displaced. So I think it's an opportunity to do things differently if we do right. And for that, we're probably going to need two things: different governance arrangements, either at the national level or at the international level, because currently it seems that actually we're working on silos, and then the climate field and experts are moving into one direction, but the migration field, development fields, humanitarians are not necessarily actually meeting to discuss in the same language and in the same terms what is needed. But also at the international level, if the countries are going to need to apply to the finance that was described this morning, they are going to have to actually have a different ways to engage in order to respond to what is needed.
Thank you very much, Ilyana. Would any other panelists like to offer some concluding remarks? Because we're more or less out of time at this stage, but would anyone else like to? Or are we?
I would just say that I completely agree with you on this issue of categories, and that is something that I think, by thinking through sort of a new normative protection piece is something that we would want to address.
Anyone else, Jocelyn?
Yeah, just to build on that, I think that we know in terms of protection for individuals that we're not necessarily advocating for people who are specifically climate displaced, but that people that are displaced or forced to move should have access to rights, and that will then protect people who are affected by climate change, among many other factors that people are affected by. And so I think that when we're looking at this, building on and defending the existing principles that affect asylum seekers is a critical piece of the climate movement, because we're watching those rights erode before our very eyes here in the US and in many other countries that will follow on to the US's lead. And so enforcing existing rules, but then building on that. As we know, we haven't had migration reform in the US for over 30 years. We need a system that meets the moment, and the moment includes climate impacts, but many other forms of persecution against people as well.
Thanks, Jocelyn. Leah?
Just to come back on the point about reparations, because I thought that was so important. I think this is exactly why we need to continue to codify the right not to be displaced. We know it will be violated in certain situations, probably many, often not for anyone's fault, but because precisely of climate change. But what that right would do is it would give you a right to reparation. So it would start to get us out of a kind of charity and humanitarian assistance ethos and into a right to solutions, right to reparations, right to restoration, right to repair style of system. And then just on money more broadly, ODA is going down. It's going down pretty rapidly, at least for now. But there are financing solutions that I think have not been brought enough into these kinds of conversations. Debt relief. Most of the countries that we're talking about are paying more in debt servicing than they're receiving, not just in aid, but if you add up aid, financial investment flows, and remittances, they're still net subsidizing the rest of the world. They're essentially bleeding money. And so debt relief would be one way, and it wouldn't require new appropriations from parliaments. It's obviously very politically complicated, but I think it should be on the table. The other one is just easing some of the other macroeconomic burdens on these countries. There's a big conversation, and definitely the Global North is leading on this, around getting out of what's called ISDS, or investor-state dispute resolution style systems under the investment treaties. These make it very, very hard for local courts to hold foreign companies who may be displacing people accountable in their own courts. Everything goes up to these private arbitrations. They essentially have a chilling effect on climate protective policymaking if and when they infringe on the current or future profits, speculative profits of foreign investors. So that, again, and there's been a huge shift. Most European countries have gotten themselves out of the ISDS system under the Energy Charter Treaty precisely because it was chilling their climate legislation. So I think this should be looked at, and a number of countries are actually trying to get out either together or bilaterally or unilaterally out of these kinds of systems. So we need to think about a different way to kind of mediate those disputes, but in a way that doesn't have this kind of chilling effect, which would open up fiscal space in these countries for preventative programming, for preventative spending, and also for spending on people who are displaced, and to try to, for instance, expand their education systems rather than have to undertake austerity. So.
Thank you, Leah, and thanks to all the panelists, and thanks to the audience for a very lively discussion. And there's a lot to take away. Personally, I was very, very struck by the issue of whether this is the moment or a moment to look at a fundamentally new framework. But at the same time, notes of caution were sounded in the room, and the debate will continue. But thanks to everybody for taking part, and to the earlier keynote speakers as well. I thought they were very, very interesting. Thanks a lot.